Today we will be discussing the landmark Second Amendment court case, D.C. v. Heller, as well as some brief background on the current Supreme Court justices. First, we will talk about the current Supreme Court justices and give some background about them. Justice John G. Roberts, a moderately conservative justice, leans more towards the conservative side, but has some liberal ideals. In the current Supreme Court, he could be considered the new swing vote now that Justice Kennedy is gone. Notably, Justice Roberts is in favor of Obamacare or the Affordable Care Act. Clarence Thomas, a very conservative justice who votes primarily conservative. His opinions stem from his Catholic background. Notably, he upheld the Supreme Court's decision of unconstitutionality of the ban on religious organizations in schools in 2001. Ruth Bader Ginsburg, a very liberal justice who votes primarily liberal. Notably, she wrote the opinion on VMI's ban on female cadets, in which the Supreme Court ruled it unconstitutional. Stephen G. Breyer, the most moderate liberal, but still very liberal, and votes primarily liberal. Notably, he wrote the opinion on the Supreme Court's ruling against the outlaw of partial birth abortions in Nebraska. Samuel A. Alito, a conservative justice who votes primarily conservative. Notably, Alito wrote the opinion for the Supreme Court ruling that anti-harassment policy did not impede free speech as the term harassment is too broad. Sonia Sotomayor, a very liberal justice who votes primarily liberal. Notably, she wrote the dissent for the case in which the Supreme Court upheld Michigan's ban on affirmative action. Elena Kagan, a liberal justice, votes primarily liberal. Notably, she held that by the Eighth Amendment, juveniles cannot be sentenced to life without parole. Neil M. Gorsuch, a conservative justice who votes primarily conservative. He ruled with the conservatives in the Chevron difference. Brett M. Kavanaugh, a very conservative justice who was just recently voted in during Donald Trump's election. Not many decisions have been made or released by Kavanaugh, so we don't have too much information on him. Before getting into the nitty-gritty about the D.C. v. Heller case, some background on the Supreme Court justices deciding in the case is necessary. Justice Roberts, as talked about before, is a conservative justice who voted in favor of Heller. Samuel A. Alito, another conservative justice, also voted in favor of Heller. Clarence Thomas, another conservative justice, voted in favor of Heller. Kennedy, the swing vote during this time period, who was a very moderate justice, also voted in favor of Heller. Scalia, another conservative justice, also voted in favor of Heller. As you can see, all of the conservative justices voted with Heller for this case. Against Heller was the liberal justices Souter, Stevens, Ginsburg, and Breyer. Although both appointed by conservative presidents, Souter typically voted in correlation with the liberal justices, and later in Justice Stevens' career, he served as the head of the liberal wing in the Supreme Court. Here's some background information and facts about the case. The Firearms Control Regulation Act of 1975 made it illegal to have an unregistered handgun in the District of Columbia. The act also limited registration to 1-year grants of the police chief and required guns to remain unloaded unless in a business or for legal recreational use. D.C. Special Policeman Dick Anthony Heller was denied a 1-year license, despite having to carry a gun for his job. Heller felt as though this was a violation of his Second Amendment right to bear arms. Thereafter, he sued the District of Columbia. The main question of this case is whether or not the provisions of the District of Columbia Code are constitutional. In more detail, whether restricting the licensing of handguns and requiring licensed firearms in the households to be kept non-functional invades the Second Amendment. The Second Amendment states, a well-regulated militia being necessary to the security of a free state, the right to people to keep and bear arms shall not be infringed. After the denial of a permit for Dick Heller, 6 residents of D.C. filed a lawsuit in which they were challenging the constitutionality of the provisions of the Firearms Control Regulations Act of 1975. The lower court dismissed the case, and Heller appealed the case in the District of Columbia Circuit Court, where the decision of the lower court was overturned in a 2-1 decision. the D.C. Court ruled the Firearms Regulation Control Act of 1975 unconstitutional. However, the defendants petitioned the Supreme Court to hear the case. The Supreme Court upheld the appeals of the Circuit Court, thereby abolishing the Firearms Regulations Control Act of 1975 and granting Dick Heller the right to own a firearm in D.C. As for the majority opinion, Justice Antonin Scalia decided that the provisions of the code requiring household guns to be kept disassembled and the ban on registering handguns infringes on the Second Amendment. The justices based the majority opinion on the militia clause of the Second Amendment, which does not restrict the operative clause of the amendment. In the concurring opinion, Justice John Roberts states that the Second Amendment protects the rights for an individual to own a firearm outside of the militia service for lawful use. In the dissenting opinions, Justice John Paul Stevens states that the Second Amendment does not create unlimited right to possess guns for self-defense purposes. Alternatively, the amendment protects the right to keep and bear arms for certain military purposes, but does not reduce the Congress' ability to regulate the ownership and non-military use of weapons. As for the other dissenting opinion, Breyer argues that even if the Second Amendment, in addition to militia-related purposes, protects an individual's right to self-defense, that assumption should be the beginning of the constitutional inquiry, not the end. Breyer contends that there are no purely logical or conceptual ways to determine the constitutionality of gun control laws, such as the district's law. In layman's terms, the doctrine of stare decisis states that the court looks to past decisions to guide their decision in a particular case. As for this particular case, prior to the District of Columbia versus Heller, the only court case based directly off the right to keep and bear arms was in the 1939 Supreme Court case, United States versus Miller. Jack Miller and Frank Layton were charged for their infringement on the National Firearms Act of 1934 when trying to enact interstate transfer of a sawed-off double-barrel shotgun. The NFA, or the National Firearms Act, created a tax for the manufacturing and moving of firearms and a tax for the people involved in the manufacturing and moving firearms. Miller and Layton felt as though this tax was a violation of their Second Amendment rights to bear arms under the Commerce Clause. The district court agreed and dismissed the case. The Supreme Court overturned the district's decision in a unanimous vote, arguing that the Second Amendment doesn't protect such weapons since they have no role in the military. The final vote, District of Columbia versus Heller, stated that the Second Amendment protects citizens' rights to have a legal, registered handgun for self-defense and legal recreational use, separate of their service in the United States military. This case overturned the previous ideas of United States versus Miller in strengthening the clauses of the Second Amendment. It overturned the limitations of owning and selling guns that are not directly related to the military. It widened the interpretation of the Second Amendment to allow all citizens of Washington, D.C. the ability to have a legal registered handgun. As for the judicial philosophies used during this court case, it consists of activism, loose construction of the Constitution, and the Constitution as a living document. The District of Columbia versus Heller court case shows strong activism in contrasting the previous case of United States versus Miller. It overturned the limitations of owning and selling guns that are not directly related to the military. In doing so, it expanded the Constitution with a more loose construction. The United States has grown significantly since the signing of the Constitution in 1787. Our founding fathers took many precautions when creating the foundations of the government. However, as new societal issues arose, unexpected revisions must be made. With that being said, the District of Columbia versus Heller shows the need for the interpretation of the Constitution to be seen as a living document. The expansion of the right to bear arms for people who haven't served in the United States military provides personal security for any United States citizen. It also allows for the development of new legal weapons to be protected under the Second Amendment as well. As conservative President George W. Bush was just leaving office during this time in 2008, the public opinions show that the majority, 91% of gun owners, agree that the Second Amendment guarantees their right to firearm ownership. Although it was less than gun owners, the majority of non-gun owners regard the amendment in the same way, at a 63% approval rate. This is significant because the public opinion is in correlation with the decision of the Supreme Court. As for the legacy of this case, the court ruled that the District of Columbia must give Heller a license to possess a handgun inside his home. In the process, the court ruled that the Second Amendment protects an individual's right to bear arms and that the district handgun ban and trigger lock requirement violated the Second Amendment. As a consequence, it is much easier to own a gun now after the ruling of this case. For the interpretation, many of the lower courts have now adopted a narrow interpretation of the decision, which allows for more gun freedom across America. Due to the Supreme Court's decision, there is unarguably more gun freedom in America today than there was before D.C. versus Heller. There are now more states that do not require licensing at all. Many states have a shall issue permit law versus the more restrictive may issue law, which leaves permitting decisions up to the discretion of local officials. More states now also have the ability for citizens to carry guns outside of their home. With the current issue of school shootings and unworthy gun owners, it will be interesting to see if any court cases overturn D.C. versus Heller in this era of the Supreme Court. Moreover, on the legacy of the case, Dick Heller is now a public figure and an idol for the gun-owning community. In the following video, he is giving a speech at the National Rifle Association convention, and he mentions how the Second Amendment right is still one of the most important rights listed in the Constitution. Enjoy the video.
Now, I'm from Washington, D.C., and it's like a tiny foreign country sometimes, where it seems like the lawmakers make it up as they go along when it comes to the Constitution. They're weak on the First Amendment, the 10th Amendment, the 14th Amendment, and they certainly don't have any use for the Second Amendment. As an example, there's a D.C. council member who is a constitutional law professor at George Washington University, who stated in a public forum that the reason she voted for all the D.C. gun control laws was, are you ready for this? A constitutional law professor voted against the Constitution because she wanted the vote to be unanimous, to show harmony on the D.C. Council. That